what should I be thinking about when I am hiring somebody to do a patent search? Hi, my name is Fahey. I'm a registered trademark attorney and a patent attorney with the Plus IP firm. And this video is going to give you some tips and things to think about when you're hiring somebody or a law firm or a searching company to do a patent search for you. So first off, there are different types of patent searches and reasons why you want to do different patent searches. And before you hire somebody, you need to think about what kind of search you want to do. For example, do you want to know if you can get a patent on an invention? And that's actually what the focus of this video is going to be about. That's called a patentability search or patent clearance search. That is a search to find all the things that exist before you filed your application, all published documents that could affect your ability to get a patent on an invention. Another type of search is known as an invalidity search. That is, in litigation, or if you're trying to compete against somebody, you can do a search to see if something else is out there that could potentially invalidate a patent. Another type of patent search is called a freedom to operate search. You want to sell a product and you want to know what else is out there, or what other patents are out there that could affect your ability to actually sell the product or that could cause a potential legal risk for you. So different types of searches. Today we're going to focus on a patent search for the patentability opinion. So generally speaking, there's a few things you want to think about when you are hiring somebody to do a patent search and opinion. There are a lot of companies out there that will give you low costs, but you need to make sure that you're comparing apples to apples. So when you do a patent search, you need to hire somebody, in my opinion, that will also be able to give you an opinion about whether or not you can get a patent. So many times searching companies will do the search and they'll put all these different references in front of you after they have completed the search for you to look at. And then they basically don't give you any analysis. They just tell you what you're actually going to be. They just basically say, hey, here's all the information. Now you can make a decision. Well, if you're not a patent attorney or very experienced in patent law, that may not be helpful for you. Okay, so you want to make sure that you're comparing apples to apples, and you want to make sure that how the person you're hiring is also going to be doing an analysis for you of all the different patent applications and how they could affect the patentability of your actual invention or your patent application, and also giving you a report and recommendations. I think it's so important. A lot of times people will tell me, I hired somebody and I did a search, and then I asked for, okay, great, well, that's great. And the person will tell me, I did a search and they told me that it was patentable. And I say, okay, great. Well, let me see the analysis of it. And there's no analysis. You want to make sure that what you're paying for is the analysis. The search, is a search, but the time it takes to actually do an analysis and give you an opinion should be also taken into consideration. And legally speaking, only a registered patent attorney in the US, like myself or other of my colleagues, are able to give you an opinion about whether or not your invention is patentable or whether or not you can get a utility patent or your design patent on your invention. Okay, so I think the biggest thing is to think about is what are you actually getting? The second thing is, before you hire the person, you want to understand their process, okay? In our firm, we have a really particular process. And I think it's really important that how the person you're hiring understands what you think is inventive. I think that how the inventor actually has a lot of input and can provide valuable input before we do the patent search. So typically what we actually do at our offices, and I think it's very important to do anyways, is to define the main elements of the invention. How we do it at our office is we actually draft what's called a patent claim that describes the most important features of the invention. And it will say element A, B, C, D. It may say something along the lines of, we are developing the software for safe communications over the internet, and then say wherein the software includes the different elements A, B, C, D, E. And why is that important? Well, one, when we do an opinion, we want to draft the claim, the elements of the invention, just like we would with the patent application. So the whole goal of the patent search for a patentability opinion is to give you a sneak peek of what you'll be looking at, down the line when it's examined by a patent attorney. And that's probably another point I should probably raise is, why would you want to do a patent search in order to determine if you're going to get a patent? Because the reason is how if you're going to file a patent application to try to get a patent, eventually a patent attorney at the patent office, at the United States Patent and Trademark Office, will do their own search based upon what the claim, the elements of the invention is. And then based upon that information, based upon their search, they'll issue, they'll render an opinion, or they'll issue an office action of correspondence to you telling you whether or not your invention is patentable based upon the law. So the reason why you want to do a patent search before you file a patent application is you want to make sure that, one, you want to know what type of patent application should you file, because you may not want to file a utility patent application because you may not be able to get a utility patent. So you want to do the search before, all right? And defining the main elements of the invention, it's important. The second part of after the elements of the invention are defined is you want to make sure that you're going to be able to give feedback to the searching company or the law firm. And the reason why that is because if you just give the information and you don't have any communication with the attorney or any feedback, you may not be able to the search firm, the law firm may have actually missed something really important to you. And because they missed something that's really important to you, you may not have that included in the search. And that may make a difference in the patentability of your invention. So, I think it's really important that whoever you're hiring is able to receive feedback and, get your input and then give you a revised version of the claims or the elements of the invention before the search. So important. You got to have this feedback loop before you search to then make sure that what you think is inventive is included in the elements for the search. Then after the feedback loop, then it's sent off to the search company or it's done in-house, and the results, after the results are received from the search company or the results are done in-house, typically the attorney will analyze everything and based upon the law give you an opinion about whether it's patentable or not. And I think it's also very important to make sure that your attorney gives you recommendations about how to proceed. Typically they would say, hey, we should recommend filing a utility patent application or a design patent application, whatever the case may be. I do also think it's really important that you're able to speak with the attorney afterwards. And the reason why is you may want to ask some additional questions that are not addressed in the opinion. Okay, so those are just a few things that you should really think about and make sure that the attorney that you're hiring is going to be doing. Making sure that they're going to be giving you a written claim just so that how you're clear about what they're searching. You want to be able to give feedback about what you think is inventive. And then after you agree, 3, you want to be able to get a written opinion from the attorney, not just the results. So you want to be really clear that you get the analysis and the opinion. That's what's key, is the analysis and the opinion. If you can, getting in writing, I think it's really important. So hopefully you found this video helpful. My name is Derek Fahey. I'm a registered patent attorney and trademark attorney with the Plus IP firm. You can find me online, www.plusfirm.com. Please like and subscribe to this channel if you're watching the video. And if you have any questions, you can reach out to me in the comments or on Instagram and TikTok, Derek Fahey, PA, DEREK FAHEY, PA. Thanks for watching and see you